Francis against the Attorney General of St Helena on the part of the Crown.
Now, Mr. Hitchens and Mr. Hafiz-Beg, I think you understand that the fifth member of the court, Sir Anthony Smelly, is with us by audio, but we don't, for some reason, have a visual link at the moment.
My Lord, yes.
But I suggest we've lost enough time as it is trying to sort this problem out. I suggest we just get started and make progress.
Yes, my Lord. So, my Lord, I appear alongside Mr. Scott, who is the Public Solicitor of St Helena. My learned friend, Mr. Hafiz-Beg, appears alongside Mr. Garner, who is Crown Counsel in St Helena.
Now, can you just explain for our benefit what the role of a public solicitor is, because we're not familiar with it?
My Lord, yes, I hope I do. Mr. Scott will correct me if I get this wrong. The Public Solicitor is a office created by statute in St Helena to provide representation essentially to anyone in St Helena who needs it. So there are no lawyers in St Helena other than the Attorney General's chambers and the Public Solicitor's office.
Yes.
My Lords, my Lady, this is an unusual appeal. It relates to the dairy to the estate of Napoleon Bonaparte's former residence in St Helena, which has since been split into units. The appellant maintains that he has been in adverse possession of 4 of those units for sufficient time to entitle him to become the registered proprietor of the units by way of prescription. My Lord, the principal question of law before the board is whether a statute passed under the reign of William IV in 1833 to govern the affairs of the East India Company, read with the savings provisions at section 159 of the Land Registration Ordinance 1980, has the effect of precluding the acquisition of Crown land by prescription. My Lord, I'm instructed that this case is the first time in the 46 years since the passage of the Land Registration Ordinance that the Attorney General has asserted that Crown land cannot be acquired by prescription. There are also 2 further issues which fall to be determined by the board. The first is whether the power of the Governor under section 31 of the Constitution to dispose of Crown land precludes the acquisition of Crown land by prescription. And finally, the admissibility of records of the proceedings of the St Helena legislature in St Helena Court. So those are the 3 issues before the board. It's our case that the Court of Appeal made 3 principal errors. First, we say that it misunderstood the scope and effect of section 112 of the 1833 Act. That's the Act now known as the St Helena Act 1833. Secondly, we say it erred in its construction of the savings provision at section 159 of the 1980 Ordinance and the type of interests which are protected under that saving provision. Thirdly, we say it failed to have regard to the available legislative material on what we respectfully say was a mistaken understanding that the parliamentary material was not admissible. So those are the 3 principal issues which we say arise for determination in respect of why the Court of Appeal judgment was wrong. And then once I've addressed those 3 issues, I'm going to address very briefly my learned friend's argument about section 31 of the Constitution. So, my lords, my lady, before I move on to the body of error 1, which relates to section 112 of the 1833 Act, I'm just going to set out very briefly the structure of the issues, which I develop in much more detail in due course. So, my lords, my lady, section 135 of the 1980 Ordinance, which we're going to look at in detail in due course, provides that the ownership of land in St Helena may be acquired by peaceable, open and uninterrupted possession for a period of 15 years without the permission of any person lawfully entitled to such possession. Section 160 of the same ordinance provides that the 1980 Ordinance binds the Crown and the government. And then section 159 provides that nothing in the ordinance affects, and I'll say prejudices, but I'll come on to that, any of the interest, rights, powers and privileges conferred on the Crown or the government by any other written law. So what the Court of Appeal of St Helena held was that Section 112 of the 1833 Act created an interest, it appears in all land in St Helena, but certainly in this land, held by the Crown, certainly all land that was not purchased in St Helena was not purchased by the Crown in St Helena. That appears to be the basis of the decision. And therefore, there was an interest in this piece of land that was protected by the 1980 Act under Section 159. So can I start just by taking you to the text of the 1833 Act, please? And we'll start, if we may, at page 1364 of the record. 1364? Yes, please.
Yeah. We obviously we'll hear what you have to say, but we won't lose sight of the fact that the question that the registrar stated for the opinion of the court was simply, can Crown land be acquired by prescription?
Yes.
And that's end of the day, that's the question that the Court of Appeal also had to answer.
Yes, and I'll take your lordship to what the Court of Appeal said about this, but what they appear to say is any Crown land that was not acquired through the Crown purchasing the land concerned cannot be acquired by prescription.
Yes.
And that was founded on the wording of Section 112 of the 1833 Act. Yeah. And I say, just to flag where I'm going with this, what I say is that when one considers the correct construction of the 1833 Act, actually all that was transferred was land that was owned by the East India Company, that was fit for the service of government, and therefore, if land did not fall within that category in 1833, then it can't be relevant to Section 159 in any event, because no interest or right would have been created through the statutory conveyance created by the 1833 Act.
But don't we have to assume, for the purpose of answering this question, that this land was land that vested in the Crown under 112?
Well, my lady, I say you don't have to assume that for precisely the reason my Lord Reid said a moment ago, which is the question for the registrar and subsequently for the Court of Appeal was, can Crown land be acquired by prescription? Now, the answer that the Court of Appeal gave is no, it can't be acquired by prescription because of the 1833 Act. So the conclusion which the Court of Appeal reached...
Well, and also, of course, because of Section 159.
So that's the second limb of my argument, which I'll come on to, my Lord. But for present purposes, my answer to my lady is that if I can establish that all land in St Helena did not get conveyed to the Crown in consequence of the 1833 Act, then it can't be that the 1833 Act is a reason for Section 159 to preclude the acquisition of any Crown land in St Helena by way of prescription.
But say we weren't with you on that argument. Say our primary focus is actually the correct interpretation of Section 159.
Well, I come on to that, my Lord, in detail, and I'll just say what my argument in the response.
I don't think the Crown is arguing that if they've bought land over the course of the past century from some private owner, that then is protected from prescription.
No.
No. So, as I say, the question may be rather broadly worded, but the question is really, is land which was vested in the Crown by Section 112 protected from prescription?
Yes, and my lady, it's at page 81, paragraph 57. It is the way that the Court of Appeal framed this, so it might be easier to address your ladyship's question in reference to that paragraph.
Which page again?
It's page 81. Paragraph 57. Just wait a moment, if I may.
Yes, just while that movement's going on, when you said page 81,
I'm so sorry. Yes, page 81 of the hearing bundle for today.
the electronic.
Electronic.
Yeah. Sorry, yeah.
Yes, it's slightly confusing. Our hard copy has a different numbering from the electronic one, but we know you're referring to electronic numbers.
Yep.
So the conclusion which was drawn by the Court of Appeal, I say, appears to be that there are effectively two categories of Crown land. There's the category of Crown land which was purchased, and it was conceded, as precisely as my lady says, it was conceded by the Attorney General that that land would not necessarily be caught by Section 159. And there's the rest of the land, the Crown land, which was acquired by operation of statutes, in this case Section 112 of the 1833 Act. And the Court of Appeal appeared to proceed on the basis that category of land is protected by Section 159. But
just out of interest, if it were right that there's a dual or bifurcated regime in relation to Crown land and the effect of prescription on it, what would be the purpose of that? How would it relate to the land on the ground? I mean, is there any special category of land that was acquired?
my Lord, this...
Or would it purely be happenstance which bit of land you fell into?
Well, this is something that I come on to in my submissions in respect of 159. Firstly, there are very incomplete records in St Helena of property ownership, so it's entirely unclear that the Attorney General will be in a position to identify which pieces of Crown land were purchased and which have been acquired by prescription or other statutory means. That's the first issue. The second issue, and I developed this point in a bit more detail in due course, it would be completely contrary, in my respectful submission, that state of affairs would be completely contrary to the legislative purpose of the 1980 Act and would be entirely unworkable. And in answer to my Lord's question, there's no acquisition status recorded in the land registry or any other public records which would clearly identify which land has been acquired by statutes and which has been acquired through, for example, purchase. Did that answer my Lord's questions?
Certainly for the time being. Yeah.
I'm grateful.
Thank you.
I mean, on the face of it, it would seem to have no rationale at all.
It would have absolutely no rationale. And I take your lordships and your ladyship in due course to an authority which sets out what the purpose of adverse possession and prescription is in public policy terms. And it would be completely contrary to that public policy purpose. Just to finish answering my lady's question, you'll see, just in terms of whether this issue is before the Court of Appeal, you see at page 79, which is paragraph 47 of the bundle, Mr. Scott, who represented the appellant in this, represented my client before the Court of Appeal, made the argument that Section 112 didn't vest any interest in land in respect of this land. And you'll see at paragraph 48 what the Court of Appeal said about that. So I say that this is an issue, in my respectful submission, which does require resolution. Now, I was going to I'll take you to the Act, if I may, which is starts at page 666 of the bundle.
I'm sorry, the page number?
666, my Lord.
Thank you.
And you'll see that there's a lengthy recital, but the helpful section of the recital starts, and whereas the said company. It's about halfway through that dense paragraph of text on the first page.
Yes.
Just give your lordships and your ladyship a moment just to read that extract. There's no need to read the whole of the paragraph, but it's just up to subject to debts and liabilities now affecting the same be placed at the disposal of Parliament. So I say what this indicates is the intention of the Act, and we'll go to the section in one moment, but the intention of the Act was to place the lordship or the sovereignty over St Helena, to transfer that from the East India Company to the Crown, and that's in a public law sense. And secondly, to place certain property owned by the company at the disposal of Parliament to effectively transfer it to the Crown. And then I say we find out what property precisely is to be transferred at page 698.
So the sovereignty is transferred in respect of all the land, whoever
Yes.
actually owns it in
Yes.
a private law sense, because even if I own my house, it's still within the jurisdiction of
Yes.
the United Kingdom government. So you're making that distinction.
There's a distinct, precisely, my lady. I accept that the sovereignty over the entirety of St Helena, of course, transfers, but then there's a second question, which is what property transfers under section 112. And then we find...
Well, I mean, sovereignty wouldn't transfer because the East India Company wouldn't have possessed sovereignty in a public law sense. It was simply a private proprietor of what amounted to an empire.
Yes. Well, I think the best distinction perhaps is between private and public law provisions. So in terms of public law, of course, the East India Company had courts, a governor, laws. It fulfilled a lot of the functions that the state would fulfill, whether that's a
But it
question
was
of...
well, it had a private army. I don't know if... I don't know what basis courts in India, for example, functioned during the period when the East India Company administered all that territory.
Well, there's some answer to that on the next reference that I'm taking your lordship to. But just to answer your, and I'll take your lordship through that, but just to answer your lordship's question, whether it's a question of sovereignty or not, that there was a public law provision, which is that the administration responsibility is expressed in Georgian language as lordship, but the administration responsibility transferred to the Crown. And then separately and distinctly, there's the question of property. Now...
Sorry, can I just understand this? In the long section 1, which is, I assume, what it is, although it looks like a sort of recital, but
Yes.
it in fact is section 1, I think. I mean, the vast majority of that is dealing with something other than St Helena.
Yes. The history of this Act. So the history of this Act, the principal purpose of this Act was to govern the affairs of the East India Company in respect of the entirety of its domain, so primarily the Indian subcontinent.
And the British territories in India were to remain under the government of their company.
Yes.
To read out the marginal comment.
Yes.
Yeah. Yeah, so I'm just looking at the italicized words in the opening lines. It's referring to an earlier statute which continued in the East India Company the possession of the British territories in India and established further regulations for the government of the territories and the administration of justice within the same. So it looks as though even then the Crown was claiming, was asserting that the territories were British territories, but giving possession and powers of government and administration of justice to the company.
Yes, my lord. And there were a series of, since the Charter was initially issued, there were then a series of Charter Acts, which tended to come, I think, every 20 or 30 years, which essentially renewed the Charter and set out the basis upon which the Indian territories would continue to be governed.
And equally,
this is one of these Charter Acts.
When one reads on, it says, about 12 lines in, and whereas the said company are entitled to or claim the lordships and islands, so lordships and islands, so a lordship is some sort of way of designating territory. The lordships and islands of St Helena and Bombay under grants from the Crown. So again, it looks as though the legislation is proceeding on the basis that the Crown had the sovereignty over these over St Helena and Bombay, but had granted those lordships and islands to the company.
Yes. And I suppose wherever we land in terms of sovereignty, the important distinction for the purpose of my argument is between public law powers, which did transfer, and powers of government administration, versus the extent of the transfer of private law ownership over specific properties. And that question is resolved, as I say, on page 698 of the record, which is where we find section 112. And you'll see what is transferred is forts, factories, public edifices, and hereditaments in the said island, and all stores and property thereon. And this, in my submission, is the crucial words: fit or used for the service of government, shall be vested in His Majesty. So I say, when one reads the course...
You didn't mention the opening words, that the island of St Helena.
Yes. And I'm going to go to in a moment what Benyon says about how you interpret historic statutes of this nature. What I say is there are essentially three questions when it comes to the question of private property under this Act. One, does this transfer all private property on the island, whether held by the East India Company or others, in which case it would have effectively abolished private ownership of property in St Helena? If it doesn't do that, does it transfer all East India Company property? Or, third option, does it just transfer East India Company property which is used for or fit for the service of government? Now, I accept, in response to my Lord Reed's question, I absolutely accept this is ambiguously worded.
Well, I'm not suggesting that it is. It wasn't what I was meaning.
I say that the island of St Helena could have two different meanings. It could mean in a private law sense, or it could mean the public law power, the government and administration of the island of St Helena is vested in the Crown. Otherwise, the question would be, what would be the need to specify specific types of property that were to vest if the whole thing was to vest?
Well, how specific is it? I mean, you get some examples: forts, factories, public edifices, but then it says hereditaments whatsoever in the said island.
Yes, and then you have used or fit for the service of government.
Comma, and all stores and property thereon fit or used for the service of the government thereof, comma.
Yes.
I mean, stores and property aren't necessarily real property, but hereditaments whatsoever would seem to encompass all immovable property.
I say, my Lord, and I accept this is... I accept that there are alternative interpretations of this statute. I say what this is providing is, one, public law administration transfers. That's what the first sentence means. And then I say the references to specific property, real property or otherwise, is qualified by fit for or in the use of government. And I say if there was an alternative interpretation to that, the effect of this provision, which has never been read in this way before, would have been to effectively abolish all private law ownership of property in St Helena in 1830.
Well, it would have had the effect of expropriating whatever land was it 1833 owned by other people and transferring it somehow to the government. But I think if one looks at 112, it's a bit of a combination of what you were calling sovereignty versus private ownership, because of course the last clause about the governance of orders of His Majesty in Council, that is presumably saying that the jurisdiction of the island of St Helena is now to be exercised, lawmaking powers are exercised by the King in Council as opposed to the East India Company, and that applies to the whole island. All the island, whoever owns bits of it, is governed now by orders in council, and that is the island of St Helena. But it also mixes in with that the transfer of some actual private property ownership to the Crown, and you say that is a subset of that because it's not expropriating all the land that's at that moment privately held in St Helena, and that is all stores and property fit all, well, there's then a query about how much of
Yes.
the private land is transferred, but that I think is a distinction that you're making, that the orders in council bit applies to the whole island, but the vesting of private ownership applies to a subset of...
A subset of private property that is fit for or used for government.
Do we know if there was private ownership, or was there any privately owned property on St Helena in 1833?
There was, my lord. This is referred to in the arguments before the Supreme Court and the Court of Appeal, and I don't understand it to be contested. I'm instructed one of the largest landowners, of course, was the church, who privately owned land, and they continue to hold land which they owned in the 19th century. So if the Court of Appeal were right and all land in St Helena was expropriated, then that will call into question the private law property holdings of St Helenans today. So I'm sorry, my lord.
Sorry, no, I was about to ask you. Can I just go back a touch? If we go back to 666 and the words that you referred us to, which start about a dozen lines in, 10 lines in, and whereas the said company are entitled.
Yes.
As I understood it, what was going on here was that the East India Company were entitled to or claim the lordships and islands of St Helena under grants from the Crown. We don't have those grants from the Crown, but there seems to have been something which the Crown granted to the East India Company. And as an exception to the rest of the Act, which is dealing with everything else that the East India Company owns, because that's the bulk of the Act, as I understand it. And you can see that what it was doing, I think, was to continue the delegation, if for want of a better expression, of government of all the other bits of land to the East India Company for a period which ran from 22nd of April 1834 to the 30th of April 1854. You can see that in the middle of the page. As an exception for that, there's a one provision dealing with St Helena, which is section 112. Is it not just basically effectively reversing the grant which had previously been given by the Crown to the East India Company?
That's precisely the statutory purpose.
So do we know which bits of St Helena were previously granted to the East India Company? Because it would be surprising if the vesting in section 112 was of anything more than had previously been granted to the East India Company by those grants that we don't seem to have.
No, my lord, we don't have that grant. But I say there are two. If one accepts the proposition that there was private law ownership in 1834, there are two permutations. Either the Crown only granted part of the island to St Helena, to the East India Company in a private law sense, or it granted the whole of the island, and then the East India Company had chosen to dispose of parts of that grant and sell it to other people.
And whatever was left, as it were, in the grant is what was revested.
It's what reverts
in the Crown by section 112, together with stores and property thereon, which may not have been, by their nature, the subject of the initial grant, because stores and property probably change.
Yes.
I mean, by stores and property, you mean food and bits and pieces.
Munitions, perhaps, in this context, yes.
Stocks of tea.
Okay. And
So, my lord, my lady, can I just go briefly to Benyon, which is at 1364, please. And this dovetails with my Lord Snowdon's observations. Just ask you to read under construction of old acts.
May we have the document, the electronic document under reference, please?
I'm sorry, it's 1364.
Thank you.
It's just over the page as mentioned in this extract. So, my lords and my lady, I say this is a classic example of a Act of Parliament which has not been drafted with the precision or clarity which would be expected from a statute enacted today. And what's clear, I say, from this is the approach the court ought to take in those circumstances to adopt a purposive interpretation to give effect to what it considers was parliamentary intention in passing, in this case, section 112 of the 1833 Act. I say there was nothing in the 1833 Act which indicates that the intention of Parliament was to expropriate all privately held property in St Helena. And that if that was the intention, you would expect that to be stated explicitly. Now, there is obviously the question of whether this particular piece of land did transfer or did not transfer in 1834 would be a question that would have to be dealt with at first instance and be remitted if the appellant was successful before your lordships and your ladyship. But I'll just flag there is positive evidence which indicates that the house was not used for government purposes, or rather the dairy was not used for public purposes in 1834. We haven't applied to adduce that evidence, but we have it. So I raise that just to say that this is a live issue as between the parties. So it is a potentially significant issue in determining this case.
And if say, the East India Company, I don't know whether this kind of concept existed at the time, I suspect it did, that the East India Company had owned the freehold of land and had let it out to somebody, a business or something that was operating from there, then I would guess that what was transferred to the Crown was the freehold subject to that lease or license or whatever permission was given, rather than suddenly bringing the lease to an end.
Well, my lady, we may have an answer to that, because if I could ask you to please turn up page 1362. Now, this is an extract of a report dated in 1834 from a commissioner of inquiry setting out the ownership of Crown land. And you'll see, I'm just finding the reference, forgive me. You'll see Longwood and Deadwood comprise, so this is the piece of land that we're talking about. Longwood and Deadwood comprise the greatest number of continuous acres. And you'll see the one, and then about midway through, the one bracket is now let by the society at £45 per annum, was formerly occupied by Marshall Bertrand, so that's next door to the units that we're talking about. The other was inhabited by General Bonaparte, now used as a farmhouse surrounded by numerous outbuildings, formerly barracks, well adapted to agricultural purposes. And then it says the Longwood Society declined to renew the lease of their farm. So, this is the Attorney General's document, so my learned friend will be able to assist your Lordships and your Ladyship further.
You know, the more I look at this, the more I wonder whether we're in a position to deal with this. I mean, just look at 1361, Appendix 3, and the foot of a page, an account of the expenditure of the civil, ecclesiastical, judicial and military departments on the St Helena establishment for the year ending April 1884. And then if you look at Appendix 9, a return of all persons holding civil, judicial or ecclesiastical offices in the island of St Helena, distinguishing each office, etc., whether entitled to a retired allowance of what amount under the company's regulations, whether provided with official residence, and so forth. So, I mean, at first sight, this rather looks as though not only the judges and the civil servants, but even the church were holding offices in the service of the East India Company.
Mm. Well, this is like a little sort of a doomsday book of St Helena.
St. Helena,
working
yes.
out
Yeah.
what are we getting as the
Yes,
Crown.
that's the purpose of it.
Yeah.
The only reason I flagged this is to say
Leasehold did exist.
the leasehold did exist over the relevant property.
Yes, so the point I'm making is that the fact that there were churches, for example, doesn't mean to say that the Church of England was vested in any property there.
Well, it's not the Church of, as I understand it, the Church in St Helena is part of the Church of South Africa today, the Anglican community in South Africa. I don't know, my lord, what the position was in the 19th century.
No, exactly. We just don't know.
Right, but I don't think you're asking us to decide whether this was...
I'm not asking you to decide.
You're just saying this is a live issue, but the point is, even if we have to assume, to answer the question, that this was actually land over which not only sovereignty, but property, private property was transferred, how does the ordinance apply to it?
Yes, and it's an issue of some complexity. And it goes to, my lord, my lord Snowden's question earlier about what would the practical implications of having two tiers of public land in St Helena be. It is a very confusing picture with very limited records and gives rise to very serious practical implications, I say. So my lords, my lady, those are my submissions on what the effect of section 112 was. That's what I say the first error of the Court of Appeal was. I say the statute certainly did not transfer all private property in St Helena into the ownership of the Crown. To have done so would have been a profoundly unfair and, in my submission, an absurd outcome of the legislation. And that interpretation should only be adopted if there is no other interpretation available. And I say a reasonable interpretation of the legislation is that the words fit for and use of government property qualified the property that was the private property that was to be transferred, and that the statutory purpose was precisely as my Lord Snowden said, simply to unwind the grant of St Helena, which had previously been made by the Crown.
I mean, 1363 is a page dealing with land. All the property is either simply occupied or with a recommendation that a lease might be granted, or it's let.
Yes.
I'm not taking it for granted there was any property which was actually vested in private hands.
I'm sorry, my lord.
I'm not, at the moment, taking it for granted that there was property on St Helena that was vested in private hands. I haven't seen any evidence that there was. And, you know, I really wonder whether this is an issue for us at all. Your best point might be that the Court of Appeal wasn't in a position to form any view about this either.
Well, if we go to page 79, please, of the bundle, and paragraph 48, I took you to paragraph 47 earlier, where it was expressly the existence of private ownership of land was expressly relied upon for the Court of Appeal. You see at paragraph 48, that proposition is accepted, or certainly not dismissed by the Court of Appeal. That point was never contentious when it was raised before the Supreme Court or the Court of Appeal. So throughout these proceedings, the basis upon which the case has been advanced is that there was private law ownership in 1834. So it's for that reason, my lord, that there isn't evidence before the court setting that out, because it just wasn't understood to be a contentious issue as between the parties. And indeed, it was appears to be the basis upon which the Court of Appeal proceeded. So my lords, my lady, if I could then move on to what I say the second error was, which is section 150.
Before you do, Mr. Hitchens, can you hear me?
Yes, I can, my lord.
This is, if one were to take your approach for a purposive construction of section 112, and regarding the provision as effecting a reversion of such interests of the East India Company as had remained at the time when it was reverted to the Crown, would one be able to say that it was only those interests to which the section referred when it spoke of the island of St Helena and carried on as it does in the other provisions, which of course would comport with your secondary proposition, which it speaks only to EIC property rather than the island? And would that avoid this anomalous construction which would lead us to the confiscation of private property?
So, my lord, I'm sorry, the sound wasn't fantastic where I was standing. Was your lordship's question that if I were correct in my submission that it only unwound the grant, that would avoid the expropriation of private property not belonging to the East India Company?
Yes.
Yeah, my lord, precisely. That's.
And would that then equal a valid purposive construction of the section?
That would be a valid purposive construction of the section. Yes, my lord.
Yes, thank you.
Grateful.
I mean, do we know, I mean, if this grant is assuming rather more of a central place in this argument than certainly I had thought, when you say we don't have it, does that mean that nobody can find it, or is it just that it's not in the bundle, the grants?
My lord, I've had a trip to Kew, and I haven't been able to find it. I know a lot of the records are held in St Helena. I don't know whether it's something that the Attorney General would be able to assist with or not.
My lords, my lady, I have certainly come across some of the charters that were granted by the Crown in passing in the Inner Temple archives while looking at old St Helena statutes. None of this is in the evidence before your lordships and ladyship for reasons I'll develop in due course, but we do take a different view of the available material out there in the world beyond the bundle here.
So, can I move on to my section 159 argument? That provision is found on page 459 of the record. And you'll see at the bottom of that page, section 160 provides that the ordinance binds the Crown and the government, but it says nothing in this ordinance affects any of the interest, rights, powers and privileges conferred on the Crown or the government by any other written law. Now, there's a bit of complexity in terms of the wording of this provision. I'll explain why. If we go to page 191, please. The background to this note is that Lady Drummond, who sits in the Outer House in Scotland, is a justice of the Court of Appeal of St Helena, also used to be Crown Counsel in St Helena happily. So she was aware, her ladyship was aware, that there was a change in wording and asked for the party submissions on why that was the case. You'll see at paragraph 2 of this note, you have the original wording.
Sorry, do you have... I've missed the page off.
I'm so sorry, it's page 191, my lord.
Sorry, thank you.
You see paragraph 2 provides, the wording is not shall affect, but rather shall prejudice. See, that was the original wording. At paragraph 5 on page 192, you have an explanation prepared by Mr. Garner setting out the history of this provision, and you'll see that it appears it had never been amended by the Legislative Council to change the wording. And then at paragraph 6, you have an explanation that the Attorney General's Chambers and my client believed that the provisions wording was changed by the Law Revision Commissioner under his powers. But we don't know when or for what reason. And it appears we don't even know whether it might have been by mistake. And it's common ground between the parties that the Law Revision Commissioner cannot change the substantive meaning of a section. So all of that is to say that your lordships and your ladyship, in my submission, should read section 159 as nothing in this ordinance shall prejudice any of the interest, rights or powers as opposed to affect.
Or it should be read as adversely affect. Is that what you say, though? There's a connotation in prejudice that it's an adverse effect.
Precisely, my lady, yes. And my headline submission in all of this is that the Court of Appeal erred in concluding that a conveyance by statute creates the kind of interest, right or privilege in that specific parcel of land that falls to be protected under section 159 of the ordinance. In fact, where the ownership of a piece of land is conveyed by the operation of law, that does nothing more than simply create or transfer private law ownership of that piece of land, and that is not the kind of privilege, right or interest exclusive to the Crown which section 159 is intended to protect. Now, this is relevant because there are a number of examples whereby land is transferred by the operation of statute in St Helena. So if we go, please, to page 449 of the bundle and look at section 121. The 1980 ordinance itself envisages a number of circumstances in which the ownership of land can transfer by operation of statute and sets out a procedure for dealing with that. So this argument is not unique to section 112. If the Court of Appeal are right, then every time the Crown obtains land by way of statute, the operation of statute, it becomes immune from prescription. Can I give your lordships and your ladyship an example of the kind of piece of legislation which I say Section 159 was intended to protect. And we find those at page 28. Forgive me, page 27, please, of the record. This is paragraph 35 of my written case. There are a number of examples where there are provisions within St Helena law which create special privileges for the Crown and the government when it comes to the administration, the management of land. These are some of the examples which I give, but then there are examples from other jurisdictions where not only are special interests or privileges created, but legislation specifically excludes the possibility of land no longer being in a particular public body's possession. And you find those over the page at 28, on page 28, paragraph D. The Kenyan Constitution, for example, which says that certain categories of public land must be held by central government on trust for the people. Section 21 of the National Trust Act 1907 in this jurisdiction says that land vested in the National Trust shall be inalienable, and that's at page 1446 of the bundle. And then there are examples where Parliament, for example, in this country has passed acts which vest specific pieces of land in specific public bodies and state that that land must be held forever. So those are the kind of, in my submission, those are the kind of interests which Section 159 is concerned with. It is not concerned with the private interest of ownership of land, private law ownership of land, howsoever that private ownership came about. Now, I say also that the legislative history of the 1980 ordinance is also highly instructive. So we're hamstrung slightly because we don't have a white paper, we don't have any of the papers that went to the Legislative Council before the legislation was passed. But if we start at page 106, please, of the bundle, you'll read it's paragraphs 140 to 141. This summarises the submission that was before the Chief Justice, which is that this legislation essentially stemmed from the Kenyan Registration of Land Act 1963, which is the year before Kenya became independent. Then a series of overseas territories around the world, British overseas territories around the world, adopted very similar versions of that legislation. And I'm going to show you some of that legislation in a moment, and you'll see that it is effectively identical. And then there's an article, I won't take your lordships or your ladyship to it, but there's an article at 1347 of the bundle from a Dr. Cooper, which again sets out the history of the Torrens land registration system throughout the British overseas territories. So I don't understand this to be contentious, but the point is the legislation stemmed directly from the 1963 legislation in Kenya. It's been adopted in Turks and Caicos, in Belize, in a whole host of current or former British overseas territories around the world. And for that reason, I say it is instructive to look at what approach has been taken by other legislatures based on the same precedent. And I set these out at paragraph 30 of my case, which you find at page 25 of the bundle. And it might be helpful to look at them. So if we go firstly to the Turks and Caicos provision, which you find at 1978 of the bundle. And again, it's identical. It's section 135, just as it is in St Helena. The first paragraph is identical to the St Helenan provisions, and then it's provided that no person shall so acquire the ownership of Crown land. So it is instructive, I say, that on an identical draft, a different legislature felt compelled to make it expressly clear that Crown land cannot be acquired by prescription. And the reason for that is, in the absence of that provision, I say there's no reason it wouldn't be so acquirable. And then if we look, please, at 1593, we have the relevant provision in the Belize legislation. And it's section 138 here. And you'll see the approach that Belize have taken is to adopt a longer limitation period, a 30-year period of occupation that is required for public land. So again, there is specific provision for public or national land, as it's described here, for national land. And then the final example...
Sorry, I must have got a wrong reference. You said 1953?
I said 159, or I meant to say 1593, my lord, I'm sorry.
Yeah, I'm sure it was me, just heard it wrong around. Sorry. 1593.
And it's section 138 when your lordship gets there. So again, specific provision had...
What's the reason for this? Is it just that the Crown traditionally doesn't pay attention to all its land all over the place, and it's too easy then for people to set up there and...
That's the justification that my learned friend advances in his case, and I don't take issue with... I don't take issue with the proposition that there can be public policy reasons for having a different approach to Crown land. And I accept that, just as my lady says, the public resource that would be required to monitor all Crown land is a relevant factor. The point is that would be a justification for making different provision, but they haven't in St Helena.
I mean, is it right that what you're saying is, look, putting it simply, if the legislature had wanted to exempt Crown land from prescription, it would have done so expressly in the bit of the ordinance dealing with prescription and not by some linguistic sidewind under section 159.
That would have been the shorter, probably more efficient way of making my submission, my lord, yes. Precisely right, yes. That's the crux of it. That if they wish to exclude Crown land, they would have done so expressly. Now, what my learned friend might say...
And you say, but would you say it's a slightly, you say it's a stronger submission in this case, because you can always say, well, if somebody wanted to do something, they could have made it more explicit, but you're saying there's a particular template for this legislation that's been used in other territories, where you actually point to how it has actually been done, not just as a thought exercise.
Precisely right, my lord. Precisely right. And there is, of course, these overseas territories, there is a close coordination between them. They're overseen by the Foreign, Commonwealth and Development Office from central government in the United Kingdom. You can assume that the legislature and the legislative drafters in St Helena would not have been unaware of the approaches which have been taken in other jurisdictions. Now, my learned friend might say, well, there's no equivalent to section 112 in these other jurisdictions, so it doesn't get you anywhere. But of course, the answer to that is, what there certainly is in these other jurisdictions is examples of conveyance by statute. So if it was thought that somehow, and there's the same saving provisions as well in the respective Land Registration Act. So if it was thought that somehow Crown land acquired by statute would be protected by the saving provisions, well, again, there wouldn't have been a need, or certainly would have been an altered provision under the specific provisions under the prescription parts dealing with public or Crown land. Now, the final point...
Have you got any references to there being a similar savings provision in these statutes that have also got the express prescription?
Can I give your lordship an example? It's 1602. of the bundle is the Malawi example. This is the one I have to hand, but I've checked there are saving provisions in all of the registration, but this is the Malawi one. You'll see paragraph, section 159. I'm sorry, section 157, I apologise.
Yes, I see, thank you.
And then I'll just give you the prescription. And then for your Lordship's note, it's 1648 is where the prescription provision is.
I think the one at 1602 is actually Belize.
Yeah.
I'm sorry, you're quite right. That's Belize, and I just took you to the 1593, which is the Belize prescription provisions, which make specific provision for public land.
Yes, thank you.
My lady's quite right, but they're in all of the acts, is the point.
So you're saying that Belize has both an express provision, no prescription for Crown land,
Yes.
and it also has the same savings provision as the St Helena Ordinance.
It has, it has a specific provision for Crown land or national land that says it has to be 30 years.
Yeah.
And it also has the same savings provision, yes, my lady, that we find under section 159 in our case. That's why I say the legislative history of this provision points strongly against the interpretation adopted by the Court of Appeal. But the final... I'm sorry, my Lord, I don't know if Sir Anthony had a question.
Just curious through it.
The final... so that's the points I make about legislative history. The next issue is the question of policy and the practical implications of the approach which has been adopted by the Court of Appeal. Now, I say that this gives rise to three serious issues. The first I've already addressed, which is it is far from clear that the government is in position to identify which property it has historically acquired by statutory conveyance and which it has purchased. Secondly, I say there is precisely nothing in the 1980 ordinance which suggests that the legislature envisaged a two-tier system for prescription claims when it comes to public land. And thirdly, I say it is entirely unclear how this approach is consistent with the statutory purposes of the 1980 ordinance. So if we go to a case called Best, which is at 1026, please, of the record.
Please repeat that page number.
Of course, my lord, it's 1026.
Thank you.
So this is the case of Best in which the issue was that the claimant's period of adverse possession, during the period of the claimant's adverse possession of property, Parliament passed section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act, which rendered that occupation a criminal offence. In consequence of the period of the occupation being a criminal offence, the registrar refused to register the claimant as the proprietor of the property. Now, the claimant then brought an application for judicial review, which he succeeded on, and then there was an appeal to the Court of Appeal. So can we start in terms of the body of the judgment at page 1081, please? And if I could just ask your lordships and your ladyship, if I may, to read paragraphs 80, 82 and 83.
This is in the judgment of Mr. Justice Sales.
This is, I think, Lord Justice Sales' section of the judgment, my lady, yes.
Sales J.
Oh, I'm so sorry, it's Mr. Justice Sales, you're quite right, this is first instance. Oh, my own friend tells me I was right the first time. It is Lord Justice Sales, but he was his lordship was mislabelled in the law report. So this is the judgment from the Court of Appeal.
Yes.
Could it be that, no, you're right, it does say sales LJ at the top of the judgment.
Yeah.
Yes.
Yep.
Yes, because one can see that you would then have to have a mini trial as to whether the squatter had actually committed the criminal offence to some standard of proof before you could then decide whether he or she had acquired adverse possession.
Just as here, we would need a mini trial as to whether the property was initially acquired by purchase or through statutory conveyance in circumstances where there are incomplete and inadequate records available. So then, if I could ask your lordships and your ladyship please to turn up page 1088 of the bundle. This is then the then Lady Justice Arden's judgment in the same case, and it's paragraph 107 when you arrive there, please. And again, I say all the same considerations apply in this case. I appreciate that there is reference to a consultative document from the Law Commission, which of course applies in the United Kingdom and not St Helena. But I say that the public policy purposes of prescription is exactly the same in any context. Ensuring that land is kept marketable and is not sterilised by the inaction of the true owner, reflecting the fact land is a valuable commodity. It provides space for homes, offices and agriculture, but in addition to that, land can be used to raise money and create new businesses to help the economy. And then perhaps even more relevant, if we go over the page please to 1089, Roman numeral 3, and you'll see about midway through, a ladyship says, if the registrar rejects an application for registration of adverse possession because of the commission of offence under section 144, and the applicant continues to live in the property without any objection from the true owner, there can never be a registration of the title in the applicant's name. If the registrar is right, a significant change in the law will have happened by accident or at least without any express signal. And it's exactly the same point here, because if the Court of Appeal are right, it matters not how long my client remains in occupation of that property. He can never achieve registration of his ownership, even if the Attorney General takes no steps whatsoever to enforce his rights over the property. And then finally, I'll just ask your ladyship and your lordships to read Roman numeral 4, please. Only up to where it says, I attach weight to this. So I say what the board can derive from this authority is that the statutory purposes of the land registration scheme, so far as prescription is concerned, is firstly to create legal certainty, secondly to protect long-established de facto enjoyment of property, thirdly to ensure that land which is a valuable commodity is not sterilised and is kept marketable. And as her ladyship found, this reflects an economic and social imperative of supporting the economy and providing space for homes, offices and agriculture. And finally, the Court of Appeal in this case are absolutely clear that it's important to avoid a scheme, to achieve a scheme that is coherent and avoid a scheme that is based on unworkable distinctions. And I say on any of those principles, the approach adopted by the Court of Appeal in my respectful submission fails because it creates legal uncertainty. It puts Mr. Francis in precisely the position which Lady Justice Arden said ought to be avoided. It fails to protect the long-term enjoyment of land and therefore fails to achieve the social and economic purposes which Her Ladyship referred to. And finally, as we ventilate, it leads to an incoherent scheme, which consists of unworkable distinctions. So those are my submissions, my lords and my lady, on the second error, i.e. what I say is the misapplication of section 159 of the 1980 ordinance. Can I assist any further on those points, or may I move on to...
Just so I've understood, and you're saying what, as a matter of policy, we shouldn't reach that result, what, absent clear wording?
Yes.
Or perhaps it's another way of putting it. If that had been Parliament's intention, you'd have expected them to address it directly by the sort of provisions we've seen, saying, well, we know all that, but Crown land or public land should be exempted from prescription.
Yes, my lord. So I say three things. I say, firstly, the type of interest which section 159 is protecting is not private law ownership of land. That's irrespective of whether that land came into the possession of the Crown through purchase or through statutory conveyance. It matters not. And what you focus on is the nature of the interest rather than the means by which it's acquired. That's my first point. My second point is when you read the 1980 ordinance, there's nothing in it which suggests that Crown land should be excluded in this way. And my third point is, exactly as your lordship says, there are very strong public policy reasons for avoiding the interpretation that the Court of Appeal arrived at. And in order to get there, you would need much more express language, which can't be found in the statutes. And the fact that other legislatures with the same precedent have adopted a different approach is relevant to that interpretation exercise.
Can I just ask you to have a look at page 420, which is section 28 of the 1980 Act concerning overriding interests?
Yes.
What concerns me, if the Court of Appeal is correct, is that you would also, if you look, for example, at H, these are overriding interests that don't have to be reflected on the register, as I understand it. If the Court of Appeal were correct, it would mean, would it not, that electric supply lines, telephone, telegraph lines, or poles, pipelines, aqueducts, weirs and dams erected, constructed or led by virtue of any power conferred by any written law, that could not apply to Crown land?
Yes.
Which would seem astonishing to me. And similarly, compulsory acquisition, if we look at C. I mean, it would completely undermine section 28, would it not?
My lord, yes.
Thank you.
So, my lords, my lady, if I move on then to what I respectfully say was the third error in the Court of Appeal's judgment.
This is the Pepper and Hart point.
Pepper and Hart point, my lord, my lady, yes. So can I take you to the relevant extract of the legislative proceedings first, and then I will address the board on why I say it is admissible. So page 284, please, of the record.
I'm sorry, could you give me the number again?
284, my lord.
Thank you.
Does this really help you if you haven't already convinced us
Yes.
by your previous points?
Yes, it did strike us that this was... we could have quite a big argument about whether or not it's proper to have regard to this, but even if we do, does it actually give us any real assistance?
It may not, my lord. I think it's a potentially important point for St Helena and for the courts of St Helena in terms of their practice and procedure, whether or not regard can be had to the legislative proceedings. If I failed to persuade you in terms of the Act...
We don't have what they think about it because the point didn't crop up, the Section 4 point.
It didn't crop up, my lady, because and the reason it didn't crop up is, of course, the material was disclosed on the day of the hearing, so no one had an opportunity to think about it. I'm entirely in your Lordship's hands. I respectfully agree with your Lordship that, in reality, if I haven't persuaded you on my first two arguments, I'm not going to persuade you, I think, purely on the strength of this. Yeah. The reality is, I think this is the second...
really, the more important the point is, as it were, for St Helena, the more reluctant we should be to deal with it without argument below.
I entirely understand the point. This is, I think, the second appeal from St Helena in modern times. It's the third since 1950. I think the concern on this side of the board was that if this isn't dealt with by the board today, it's unlikely to find its way to your Lordships or to your Ladyship again in the near future, and that the judgment of the Court of Appeal will stand on that point. So I'm entirely in the board's hands as to whether or not it's going to assist you. If it's not going to assist the board, then I won't take up your time dealing with it.
Yes. We're not inclined to think that this will help us. And there are ways that we can, in our judgment, signal that that we're not endorsing what was said by the Court of Appeal in the absence of full argument on the point.
I'm grateful, my Lord. I'll say no more about it then. Shall I move on to my learned friend's point on Section 31 of the Constitution then?
Thank you.
So you find Section 31 at page 570, please.
570?
570.
Thank you.
Now, this is I say what this creates is a public law power for the Governor to dispose of Crown land. There is nothing in Section 31 which indicates that's an exclusive power, by which I mean that there are no other means by which Crown land can be disposed of or transferred. And my short argument in response to Section 31, I'll develop this more in reply, is that this is effectively a public law power over a changeable class of private property. It's over a class of property that will change in terms of the property that make up that class over time. And that merely allowing property over which the Governor has a public law power to dispose of to transfer by way of statute does nothing to prejudice, or to use my lady's language, adversely affect the exercise of this power or the existence of this power or right.
But, I mean, in fact, doesn't the ordinance expressly deal with this at section 26 of the ordinance?
Let me get that up, my Lord.
I mean, it's page... So, did you say go to 420, or did you go... You took us to 420, or was it 5?
I think we were at 420 moments ago.
Right,
sorry.
so, I mean, if you just put the two side by side, 420, which is section 76, and of the ordinance, and section 31 of the Constitution.
Yes.
At the moment, I can't see why section 76 isn't just giving direct effect to section 31, and that's an end of it. I mean,
where is section 26?
It's page 40, my lady.
I mean, that's making express provision for what the...
Section 31 says.
Yeah.
Section 160 makes it clear it otherwise binds the Crown. My Lord, I agree. I simply submit the Section 31 case goes nowhere, which is why I was only proposing to address your ladyship on it very briefly.
So you say, if you've got Crown land, all this says is the person who is empowered to sign the lease, sign the sale, conveyance, apply for it to be registered is the governor. You don't have to trouble the monarch with it.
Yes. It's setting out in public law terms this part of the Constitution. What are the powers of the governor? One of the powers of the governor is to dispose of Crown land, or for anyone duly authorised by him or her in writing, which presumably would include the land registrar, to dispose of Crown land. That can't be seen as creating anything which would be prejudiced by the conveyance of other Crown land by way of statute. And as my Lord, Lord Snowdon pointed out, Section 26 effectively mirrors the provision of Section 21. So there's no inconsistency in my submission. I don't propose to say anything further on the constitutional points. I may have more to say on it in reply. Can I assist your lordships or your ladyship any further?
No, thank you very much indeed, Mr. Hitchens.
Would your lordships and your ladyship like me to commence now, or to take the short adjournment first? I think it's about 9 minutes away.
I think it'd be a good idea if you were to start. We can use the 10 minutes profitably.
Very late.
We're supposed to be having a break.
Yes, that's at 3 o'clock. Yes, Mr. Haffisbeg.
Thank you, my lord. My lords, my ladies, I intend to take the issues in this order. Issue 1, as identified in the Statement of Facts and Issues, I'll deal with first. That's the issue about the savings provision in Section 159 of the Registered Land Ordinance, and the two other written laws that we say engage Section 159, being Section 112 and then Section 31 of the Constitution. I'm then going to say a bit about what is identified as Issue 2, which is the proper construction of Section 112, which my learned friend wishes to raise, we say, for the first time. In light of what's fallen from the board, I won't say anything about Issues 3 and 4, which are about the applicability and, if so, application of the rule in Pepper and Hart.
Yeah.
Now, before I move to Issue 1, can I make a couple of introductory points? My learned friend presents this appeal as the Crown reaching for a colonial relic to defeat essentially the rights of residents of St Helena. And my overarching submission is that it's nothing of the sort. The provision that decides this appeal is Section 159 of the Registered Land Ordinance. It is a provision enacted by the Democratic Legislature of St Helena in 1980. The Attorney General entirely accepts that it is open to the Legislative Council to change the Court of Appeals, the result of the Court of Appeals decision tomorrow, if they wish, to make it clear that Crown land can be acquired by prescription, notwithstanding Section 159. The point is simply that the democratic lawmaking body of St Helena has not yet done that. And if that is to occur, it's a matter for that body, and with respect, not for the board. I might start with the Court of Appeals order. My learned friend...
And when you, just to be very clear, when you say that the legislature in St Helena has not provided for Crown land to be acquired by prescription, you don't mean that in the literal way you've put it,
yes.
Because you mean that they have allowed for Crown land, some Crown land, to be acquired by prescription, but not others.
Can I put it this way? I agree with what your lordship's saying, but I would put it this way. If the board were to consider the Registered Land Ordinance in the absence of Section 159, the Attorney General accepts that Crown land can be acquired by a prescription as a matter of construction. The only basis on which the Attorney General defends the Court of Appeal's conclusion is on the basis they reached, which is that Section 159 excludes land that was acquired by virtue of Section 112 of the St Helena Act from the prescription regime. But apart from the savings clause, the Attorney General accepts that prescription would apply to Crown land.
Right, and you say that was so that when the St Helena legislature enacted the ordinance in 1980, they meant to make the distinction based upon the effect of an 1833 statute.
Whether or not they meant consciously to do it.
Well, I think you say that is the intention we should give their words.
What I will say is that the Legislative Council enacted a savings clause with, as its distinguishing criterion, whether or not a right was conferred by statute. And that enacted criterion requires a distinction to be made between rights, etc., conferred by the statute, conferred by a statute, and rights, etc., not conferred by a statute. That's what produces the result in this case. It's a result of the democratically enacted criterion.
But equally, one could say, if Parliament, if the St Helena legislative body considers that if we were to go against the decision of the Court of Appeal, they can turn around tomorrow and pass a piece of legislation that does change or reenact, if you like, what the Court of Appeal has said. So, I mean, when we're talking about legislative power and the interplay with the courts, you can play it both ways, I think. This court is always, in that sense, subordinate to whatever the legislation might say.
Yes, of course. I entirely agree with what your lordship is saying. My point is simply that Section 159, which I will take your lordships and ladyship back to in a moment, is very broadly drafted. And if the result is that Crown land that was acquired by virtue of statute is excluded from the prescription regime, that is something which the Legislative Council can correct tomorrow if they wish. My ultimate submission will be that the proper construction of Section 159 has that result. But I will come to that in more detail.
Is it the case, we've been told, I think, that the Attorney General has never previously run this sort of argument. I mean, is that something you're able to comment on or not?
If you'll give me one moment. My instructions are we're not aware in the land registry of the point having been run. In my submission, that shouldn't trouble your lordship for a moment. It's simply...
Is that because no one's ever tried to register a title on Crown land that they say they've acquired by adverse possession, or it's all been registered and nobody's ever objected to it?
I believe prescription applications on this basis have succeeded in the past. It's just that this point hasn't been taken. And as I say, I don't think the board should be troubled by that. All it tells the board is that the point's not been thought of before or not been taken. And indeed, the Chief Justice didn't hold that against the Attorney General first instance.
Well, there could be some consequences then, could there not? You'd have to unwind what's been done as done by mistake. Or the person dealing with the register would. Or it would be susceptible to that argument. Anyway, that's a side point.
I'm hesitant to answer that off the cuff. There might be questions about the finality of the orders of the registrar or possibly the court if it was appealed.
Of course.
Thank you, my lord.
May I ask
I'm sorry, my lord.
I think, before you go on, in this context, have these acquisitions by adverse possession taken place since the 1980 ordinance came into effect?
One moment, my lord. Yes, my lord, I believe the applications that have succeeded were under this regime, so they must have been since 1980.
Thank you.
Can I start by taking the board to the conclusion of the Court of Appeal, page 69 of the bundle. This is the order, the sealed order of the Court of Appeal. And your lordships and ladyship will see that the appeal is allowed. So the Chief Justice had answered the question in the negative. And the Court of Appeal allows the appeal, remits the matter for determination in light of the court's judgment. So rather than answering the question, the appeal was allowed and the remitter was made on the basis of the court's judgment. The relevant part of the court's judgment is at page 81. In the final paragraph, paragraph 58, it follows that in our view, accepting the proposition that the Crown did acquire an interest by virtue of the 1933 Act, which is how the matter was argued, the answer posed is no. So the question was answered no on the basis that an interest in land was acquired by virtue of Section 112. And on this point, what I'm inviting the board to do is to affirm the conclusion that if an interest in land was acquired by virtue of Section 112, it is protected by Section 159 from the prescription regime. There is then a secondary part of the argument about Section 31 of the Constitution, which I will return to.
Well, that might be a convenient point for us to take a short adjournment, and we'll resume in about 20 minutes.
Thank you, my lord.
Thank you.